Just so you know, this show is about scary stuff. So don't say I didn't warn you guys. And remember, don't be scared.
Episode 136, Hung Jury. War Baby here with another episode of Murderous Minors.
His mind is working on this evil, and I've seen a lot of evil in my days. But I tell you, ladies and gentlemen of the jury, it's the evil you don't see coming that is the worst evil of all.
Football season just started, so it seems fitting to check on a case that I've been following since July 2016, when a former Miami Dolphins linebacker and his wife were brutally shot in their bed while they slept, while 2 of their 3 children were in the home with them. This week on Murderous Minors, we look in on the ongoing case of Antonio and Dawn Armstrong's murders in the Houston suburb of Bel Air, Texas. Murders which their 16-year-old son Antonio Armstrong Jr. has been accused of and was prosecuted for in 2019. The opening statements, closing arguments, and the reading of the verdict were the only parts of the trial allowed to be streamed, so you'll be hearing snippets from both the prosecutors and the defense attorneys throughout. ABC 13's Courtney Fisher provided extensive coverage of the entire case as well. It's been more than 6 years since the Armstrongs were killed, and here's what we've learned. On July 29, 2016, Armstrong Jr. called 911 at 1:40 a.m., and during the 16-minute call, he told the dispatcher that he had heard gunshots come from his parents' bedroom and that their door was now uncharacteristically left ajar. He was unable to describe what kind of gunshots he heard and said that while he was hiding in his 3rd-floor bedroom closet, his 12-year-old sister was asleep on the floor below, the same floor as his parents' room. While the call hasn't been released, the prosecution did prepare a transcript that jurors were provided at the trial that includes a notation indicating that Armstrong Jr. said at minute 7, quote, "It's all my fault." There were no signs of forced entry or of a robbery gone bad, and no indication that any kind of struggle took place in the home. Police found a .22 caliber pistol on the kitchen counter along with a note that said, "I've been watching you for some time, get me," which was written using a pad and a pen from a nearby drawer. When first responders arrived, the teen let them in by disabling the home security system, sounds which were captured on the 911 call recording. It was a seemingly simple occurrence that investigators and prosecutors interpreted as clear evidence that the shooter was one of the few people in the home who were still alive. The simple fact that Armstrong Jr. had to disable the alarm worked against him in their minds, but he soon revealed to detectives that a third party had done the shooting that night, and that he'd seen a masked intruder in his house before he dialed 911. When investigators scrutinized the expensive home security system's motion sensor detection records, they say that the detectors upstairs registered movement at 1:09 a.m., leaving 30 minutes of unexplained time before the 911 call was made. Here's the prosecution.
People are shot in the head. Gunshots rang out right here. The defendant lied to you and told you when he heard that, he ran into his room and called 911. No, he didn't. The defendant called 911 at 1:40. What was he doing for 31 minutes? Not calling 911. That's uncontested.
Armstrong Jr. does not mention an intruder in the house during the 911 call, but reports indicate that an officer at the scene told prosecutors that he had heard other officers talking about that statement that night. Within just a few hours, the newly orphaned teen was under arrest for shooting his parents. His mother, 42-year-old Dawn Armstrong, was pronounced dead at the scene, lying in her bed. She had clearly been shot twice in the head as she slept, as a bullet-riddled pillow was over her face. Her 42-year-old husband, Antonio Armstrong Jr., was found the same way, lying next to her with a pillow over his face, alive though mortally wounded. The father of 3 was transported to Memorial Hermann Hospital, where he died the next day. Further implicating Armstrong Jr.'s involvement is something investigators say he said, which was that in the days leading up to his parents' murders, he'd fired his father's handgun in his bedroom, the same .22 caliber handgun that would be found on the kitchen counter when police arrived. He only said this after he was confronted with the damaging evidence they'd already discovered in his closet, with the charging document reading, quote, "Police found the bullet hole in the respondent's bedroom floor covered by a large pile of socks. Officers found a pillow and a comforter in the respondent's closet with a hole consistent with a .22 caliber bullet hole through them." Not only that, but the charging document implies that investigators believe that Armstrong Jr. also tried to set his house on fire in the hall outside his parents' and sister's bedrooms. Reading, quote, "Officers found an area of burned carpet on the second-floor landing of the residence, and lab results later showed gasoline and rubbing alcohol present as an accelerant at the point of origin of the fire. Officers found a bottle labeled rubbing alcohol and containing gasoline in the respondent's bedroom. The respondent admitted to starting the fire where the carpet was burned, but stated that he accidentally dropped a match at that location. The sports world and the family's community were stunned, first by the couple's shocking homicides and then by the arrest of their son for capital murder. During his hour-long police interview, Armstrong Jr. maintained that he'd seen a masked intruder inside the house, causing the detective to ask, quote, "But how does that person get out of the house?" The teen replied, quote, "I don't know, but I don't know why everyone is assuming that I'm the person that let them in and let them out." He continued to proclaim innocence throughout the interview and let them know that the tests investigators conducted would exonerate him. He even told them, quote, "I know it doesn't look good. I don't know what else to say to let you guys know that I didn't do it. I had nothing to do with this." Dawn and Antonio were reportedly well-known and respected business owners who owned and operated First Class Training, a successful chain of small gyms in Bel Air, Texas. Things there seemed to be going well enough, although 12 days before the murders, surveillance footage from inside the gym recorded a robbery where it seemed that 2 burglars were searching for something they didn't find. They left with a computer and the gym's alarm was never activated. Not only had Antonio Sr. played in the NFL, but he also coached semi-professional football, and at the time of his murder served as associate pastor at Spirit of Lake Kingdom Center in Houston, where his mother is pastor. Overall, the family was used to being in the public eye. Antonio Sr. was a motivational speaker with an active YouTube channel, and Dawn had even been featured by the local news when she made a quilt for their oldest son Josh as he went off to college a few years before she was murdered. Now, that same news outlet plus others across the country were covering her and her husband's murders, allegedly perpetrated by their other son. Family members were just as shocked by the allegations, with Dawn's cousin telling the press that, quote, "There was no neglect or anything, nothing that could even possibly justify the situation. This makes no sense." There were, however, thousands of text messages between the teen and his parents that depicted a recently rocky relationship based on his declining grades, lying, and marijuana smoking. Dawn was disappointed and defeated over the situation, while Antonio Sr. took a more upbeat approach, trying to encourage his son to just do better. In July 2016, Armstrong Jr. had just completed his sophomore year at the Kincaid School, a private school where his younger sister also attended, but he was already enrolled somewhere else for the upcoming school year. The defense would later say that the tuition had become too much. However, Kincaid's football coach later testified for the prosecution, stating that Antonio Sr. had told him that his son had been expelled for poor academic performance. The coach portrayed Armstrong Jr. as a standout with a high level of athleticism, weepily saying on the stand that, quote, he was special to me. I guess I treated him a bit different than I treated anyone else. The public school he was set to attend, Lamar High School, already reportedly had 2 players at his position on the football team, and he was not guaranteed to play as much as he had at Kincaid, a fact that prosecutors would later try and connect to his potential motive for murder. The defense stated that, quote, they have this theory that because AJ was not going to start at Lamar, he killed his parents. That's ridiculous. That's their motive. They don't have a motive, so they're grasping at straws. Armstrong Jr. spent nearly 9 months in juvenile detention before he was certified to stand trial as an adult, publicly identified, and granted a bond of $200,000. He pleaded not guilty and was released on house arrest to await his capital murder trial, with his attorney stating, quote, we believe he's been in jail far too long. There's a lot of people out there who think he's a pretty exceptional young man. We want to get him back in school, back with his family. He's been secluded 23 hours a day and sedated while in jail. The jurisdiction waiver moving his case from juvenile court to adult court states the following facts and allegations. Quote, the respondent is currently 17 years old and Texas law requires that he can only be placed on probation until his 18th birthday, leaving insufficient time in which the juvenile court may utilize its procedures, services, and facilities currently available to rehabilitate him. It goes on to speculate that, quote, the respondent appears to have planned aspects of the crime and, quote, practicing with the handgun used to kill his parents in his bedroom through a pillow and comforter to committing their murders. The respondent used an accelerant to start a fire outside his parents' bedroom on the 2nd floor landing, but then said it was accidental. The respondent scrawled and left a note on the kitchen counter with the handgun used to kill his parents in an apparent effort to direct what he knew would be a police investigation of their deaths. The respondent placed a hush 911 call stating he heard gunshots in his parents' bedroom after staging the handgun and note in the kitchen of his residence. The court gives great weight to this level of criminal sophistication. More than a year passed before his attorneys filed a routine pretrial motion to dismiss the capital murder charges altogether, common practice as a murder trial start date approaches. Armstrong Jr.'s motion was founded on a bombshell allegation that the state withheld information from the defense, arguing that valuable time and crucial information was lost as a result. It seems that 4 months after the Armstrong murders, in December 2016, a local woman told police a startling story that could have introduced reasonable doubt in the upcoming trial. She explained that she hired a private investigator to look into her ex-husband's extramarital activity and told Houston police in a recorded interview that it was discovered that he and Antonio Armstrong Sr. were allegedly involved in a prostitution ring. She elaborated, explaining that she was aware of alleged threats made on his life and that she knew he'd tried to change the beneficiary of his life insurance policy just before they were killed. According to the motion to dismiss, quote, the defense was told around March 2017 that this allegation of prostitution was investigated and that it was not credible, thus indicating that their investigation was complete. After they requested the documentation, audio, and/or video recordings, the defense was, quote, told that none exist. The defense felt that, quote, it goes with the theme of this case. They made up their minds right away. They arrested this man within 10 or 15 minutes and they didn't care what else came along. In June 2018, the defense received the audio recording of the woman's December 2016 interview along with over 50,000 pages of phone records related to the so-called prostitution ring. She testified a few months later at his discovery hearing in September 2018, where she could remember that phone records and bank statements helped to prove what she'd been suspecting, but admitted that there were details that she could no longer recall. The defense reiterated that this was the problem.
Right now, the prosecutors are saying, my bad, we didn't give it to you. We're going to give you a continuance. Now you have time to recover from it. We can't. So by holding on to this evidence for 18 months, you saw it right there. She doesn't remember. Some of it's destroyed. That was fresh in her mind at the time. And as a result, it's stale. And because it's stale, he can't get a fair trial.
Also in September 2018, Armstrong Jr. gave the first of his 2 interviews with local ABC 13. The then 18-year-old emotionally proclaimed his innocence, as he always had and continues to do. He told Courtney Fisher that, quote, "It's been really hard. It's not even the fact of just dealing with not having my parents anymore. It's the fact that I'm being accused of something of this magnitude. I'm innocent. There was somebody else in that house that night, and to know that this is something I'm being accused of just makes everything so much worse." His lawyer said that, quote, "We're not necessarily claiming the alarm system didn't work. The alarm system worked as it should have. The problem is that there are holes in the alarm system, even when it functions like it's supposed to function." Trial eventually began in April 2019, with the defense presenting a startling alternative murder suspect, the oldest Armstrong son, Josh, who had moved into his own apartment within walking distance of the townhome 2 weeks before they were murdered. On the night of the crimes, he reportedly showed up at the scene, with his brother's defense attorney saying in his opening statement that, quote, "When asked by the Houston Police Department where he was at the time of the murders, he refused to answer. He didn't go visit his dad when he was in the hospital, fighting for his life. He did not show up." Here are attorneys from both sides.
In the charge, it's on page 2, it's called the law of parties. And it basically says all persons are parties to an offense who are guilty of acting together in the commission of a crime. A person is criminally responsible for an offense committed by a conduct of another. They asked for that, and it's the law in this case right now. Now let's talk about that briefly. Sergeant Dagnall said he was 100% sure that AJ committed the crime. No questions about it. He's right there. Remember his testimony. He said nothing would change his mind. Okay, that's your opinion. Sergeant, the only thing I know that's 100% is death and taxes, but okay. But now they've brought before you a legal argument in the jury charge that there's someone else involved in the crime. Excuse me? They fought as hard as they could to get around all the evidence outside of this case and specifically go towards AJ. If they stand up here, Mr. Brewer stands up here and argues that the law of parties applies to this case, it's a not guilty, end of story. Because by doing that, they're contradicting Sergeant Dagnall and every detective in this case that made up their mind in 11 minutes. And they're now going to say, well, maybe someone else was involved in the crime. The inference from that is going to be, now Josh and AJ were working together. Mr. Brewer, there is no evidence of that whatsoever. Mr. Brewer, that is a desperate attempt to convict this young man and send him to prison for the rest of his life. And you didn't look at Dagnall and say, wait a minute, you told us you were 100% about it being AJ. That has reasonable doubt written all over.
It is correct. There has been a substantial amount of time spent trying to focus and trying to explain to the jury what the motives might be, what they are. Was it that the defendant was falling from his very high spot as the big man on campus? Was it his daily drug use or his drug dealing, as his grandmother indicated? Not even upon questioning, well, if AJ did it, it's drug related. Maybe it's not being able to play ball with that other private school that has the coach that can get him into the big schools, and he's upset about that. Maybe it's his constant lying and being called on the carpet for it by his parents. Maybe it was the massive trust fund that he'd have access to. And no, I don't think it is unlinked that he is talking over the phone about what kind of luxury automobile that he'd like to have the Escalade above that. I don't think that you can walk away from that. These are submitted as ideas and suggestions on motive that we do not have to prove, but we feel like it was important to get that out to you so that you could better understand the facts of this case. We cannot open up the defendant's head. Go back to Bourdar, not see that the state has to provide motive. Motive is not an issue in this case. I would suggest to you that how could it possibly be something that we could accomplish to show what the motive is beyond a reasonable doubt? It just doesn't make sense to show what the why is. The why for the unthinkable. There may be many different reasons, but it is impossible to tell you, to talk to you about why the unthinkable occurs. It is enough for the jury to understand that it is simply not an element of the case. It is human nature, however, to want to know why.
And then there were the home security system records, which the state seemed to feel provided them a slam dunk in this case, even with no gunshot residue or DNA evidence linking Armstrong Jr. to the murders. The charging document states that, quote, Protection 1 security alarm records show the alarm to the residence is armed at 9:52 p.m., July 28, 2016. The respondent's sister gives a statement that she armed the system from the panel on the second floor. The downstairs living room motion detector goes idle, indicating no internal movement at 9:57 p.m. The upstairs motion detector goes idle at 10:39 p.m. The upstairs motion detector is activated again at 1:09 a.m. The downstairs living room motion detector is activated at 1:25 a.m. The security alarm is deactivated at 1:56 a.m., the time the respondent is heard turning the alarm off and opening the front door for police upon their arrival in response to the 911 call he placed. The defense offered testimony from an expert witness who stated that the system was not a good installation, therefore its data couldn't be trusted, adding that, quote, the motion detectors aren't reliable, they're not working properly, or there was multiple people in the house. The motion sensor activity and 911 call don't line up because it didn't reflect Armstrong Jr. going to wake up his sister or going to let the police in, though the deactivation and the opening of the front door were recorded. The prosecution leaked to jurors that he'd been paid $50,000 for his testimony.
So at 1:25 a.m., it doesn't take a genius to figure this out. What gets left, what gets put downstairs? The gun, the note. What is the defendant not doing at 1:25? He's not calling 911 after hearing those shots. What he's doing is cleaning up. What he's doing is making sure his sister didn't hear the shots. What he's doing is listening, going up and down the stairs, listening to find out if his father is dead yet. He's not calling 911, uncontested. This solves the whole issue of the alarm. If you look at the alarm records, it tells you the door was closed. That's it. That's the end of it. If you logically think about the alarm system, okay, it says door closed. And you know what? We know from their piece of paper that the alarm system was working on the front door. How do we know that? What is this? The defendant shut the alarm system off, and then opened the door. And when you look at the records, it shows you that the door was opened. Period. The alarm had no problems whatsoever. Not just the motion detectors, but the contacts on the doors and windows had no problems whatsoever. And you heard the expert, so one of the last things I'm going to say about the alarm, you heard the expert say, listen, if anybody bypassed or anything, and it doesn't matter, because the alarm told you, the door was closed, he disarmed it, and then it shows the door opening, the front door opening. And then you know what? Even past that, it shows after that the back door opening when the police officer opened it to let the other officers in. The alarm was functioning. Not only was it functioning, it was functioning perfectly. That is virtually the end of the story for them.
When Armstrong Jr.'s sister testified, she stated that, quote, sometimes the alarm would set when a door is still open, or sometimes it would go off unexpectedly. It was really finicky. The defense called a witness seemingly trying to direct jurors' attention away from Armstrong Jr. and toward other possible suspects. An ER doctor and former member of the gym, who opened a competing gym with one of the trainers after they became a couple, took the stand. She testified to receiving threats at the new gym, saying that, quote, I noticed on the way home there was a piece of paper on the windshield flapping in the wind. I was very afraid, adding that the note read, quote, we are watching you. Although she didn't know what it was about, she was pretty sure it had something to do with the gym. Armstrong Jr. was already in custody when at least one of these incidents occurred. They also called his supportive long-term girlfriend, who didn't waver until confronted by the prosecution under cross-examination about a text message where she told him something like, I feel like you're always lying to me, after accusing him of hiding why he'd been kicked out of the Kincaid school. After the 911 call was played for the jury, the defense wanted them to understand that, quote, he had nothing to hide. One thing that you can get out of his statement is that AJ consistently told the detective, you're going to find no evidence that I was involved regarding gunshot residue, DNA, blood, anywhere. He constantly told the detective that, and it turned out to be true. It turned out to be accurate that none of that evidence existed. They basically railroaded him.
Something was made of the gunshot residue. This is Defendant's Exhibit 14. This is what the defense showed you. It is a gun going off. It's demonstrative. It shows a huge cloud of smoke. And of course, what we have here is, hey, look at that from the defense. We have a lot of gun smoke going. This is not, in fairness, is just demonstrative in nature. But all this gun smoke, there must be gunshot residue, and there is none. And it was all very important until we learned that his hands are almost incredibly immaculate and clear. Of the gunshot residue, of course, but of something like lead. And the other elements consisted. None. How is that possible? When you have this big cloud of smoke, and then you look at it and you study more, that these elements show up on his clothing, on his shirt. Oh, and wait, there's more. The concentration is on the right side, and he has indicated to the officer, Jimmy James, that he is right-handed. Practice shots, and incidentally, from the practice shot, the testimony is, if you look at all the evidence, the last person with the murder weapon is the defendant in this case, up until the murder. There's no other indication that it went anywhere else.
When Dawn and Antonio Sr.'s daughter testified as a character witness for her brother, she was questioned about their older brother, who's adopted, saying that while Armstrong Jr. had a good and normal relationship with their parents, their older brother had conflict with their dad. She stated that, quote, he acted like our parents loved us more because we were biologically related to both of them. He acted like the black sheep of the family. He was there, but he wasn't there. He was distant. His drug use had increased and he'd become violent, she said, testifying that he'd been hearing, quote, demonic voices. She also testified that Armstrong Jr. was looking forward to starting at his new high school. The defense soon rested their case, and following closing arguments, the jury was tasked with determining whether the state of Texas proved beyond a reasonable doubt that A.J. Armstrong shot and killed his parents, Dawn and Antonio Armstrong, after a 24-day trial. Over the equivalent of 11 days of testimony, the state called 28 witnesses while the defense called 9, but not Armstrong Jr. because he didn't testify in his own defense.
Let's move backwards and see, okay, he killed his parents. What was going on in the months and weeks and days beforehand? Well, we start in October 2015. Son, you can do this. We believe in you. You got to bring up your grades. You can do this. We go into, and then he gets a car, a brand new car. Then we get into January. You're lying to us. February. You're starting to lie to us. March, April, May. It gets more somber. And you know what? I don't care if you guys looked at all the text messages. I brought these to court. I'm not scared of them. It is within context. They're still allowed to joke and laugh in between the fact that he's constantly getting grounded. He got his brand new Mustang taken away from him. Can't see his girlfriend. Gets kicked out of Kincaid, where all his friends are. Junior year. Parents aren't doing anything about it. They're not fighting for him to go to St. Pius, where he can be a star again. All these are life changes going on. And we're looking at this going backwards, which means if we were going forwards, we'd be able to predict who's going to kill their parents, right? Oh, he's smoking weed. He's going to kill his parents. Oh, he got grounded, got kicked out. No, that's not how it works. This is about this defendant, not every teenager that's smoking weed, blowing money, or anything like that. No, it's about him and what was going on in his life and what was important to him. So now we're at, the days and weeks beforehand, the iPad. We know that, and this is concrete evidence. This is, like I said, his family, they're always going to fight for him. But that's why this evidence is so important. On the 26th, he lit the house on fire. And we know that that's when it happened. That's concerning, isn't it? Does it mean every kid that pours gasoline at the top of the stairs of his house when his parents are there and his sister's with his grandma, does that mean that they're going to end up killing their parents? Not everyone. But isn't it telling that this is just a few days beforehand? So he gets his phone taken away. We know he gets his phone taken away. It's there. So he doesn't have a phone. He has an iPad. Not Josh, the defendant, has an iPad on his floor. What does that mean? Well, doesn't mean anything, right? Nope. Guess what? We have records. It means he logged in with his Apple ID on the 27th, on the morning of the 27th, on the morning after he tried to light his house on fire, and looked up how do you rig a car so that it explodes when it's turned on? Okay, we all have crazy things in our phone, right? We watch forensic files. We're going to Google something. Does that mean if I Googled something crazy that I'm going to kill my parents? No. We are looking backwards at what was going on in this person's life. Okay, so try to light the house on fire, got my phone taken away, I'm on my iPad looking at this, and then at some point, I'm shooting my father's gun through the floor of my bedroom and then covering up with socks. And I encourage you, ladies and gentlemen, please do. But I'm glad this isn't evidence. Go through it. You will see a lot more. You'll see Kyra's text messages in here. You'll see Josh's text messages here. And you know what you see? By July 10th, AJ was trying to spend the night at Josh's house. Josh was in his apartment already. So all these clothes and the iPads and all this stuff in the room, it's the defendants. What you'll see, I think, July 18th, somewhere around there, Kyra wants to go to the movies. Well, AJ's already seen this movie. Josh texts and says, I'll take you this Saturday. They're all having happy conversations. I don't see any indication that Josh is mentally ill in any of the evidence that I've looked at. And the defense told you that there'd be evidence for the past 3 years that Josh is mentally ill. We don't have that here. This is what we have. Where's that evidence that we were going to see? That Josh was having all these mental health problems, homicidal thoughts before the murder? Go look at the messages. Because it's communications. It's who this family was and what was going on. So now we get to the day of the murder. I didn't make you guys go through all of it, but please do spend all the time you want, and you'll see that this was not a happy individual on the day of the murder. He was not. He was grounded. He couldn't drive the car. His girlfriend was out partying. He wanted to be with her. He wanted to be anywhere else but home watching Netflix all day. Kyra texted him around 8 o'clock, can you come get me? Go look at the messages. I can't. Mom said I can't drive. Kyra gets permission for him to drive. He's also texting Josh. Josh is working and in school at the time, and also telling the defendant, I can't let you take the Mustang. You drive so crazy, and Mom and Dad said no. Does that sound like a protective older brother that's trying to do the right thing? Or does it sound like a homicidal guy that's about to just go crazy and commit these murders? And I'll let Mr. Brewer get into the fact that it's physically impossible. But what's going on here? We have someone whose freedom is restricted, who is failing out of school, losing focus, can't drive. Now he has to go pick up his sister. And the reason why I bring this up is that is when he had the conversation with his girlfriend. And so it was a lie that she heard his parents laughing in the background. It didn't happen. Go look at the records. It never happened. That text message that caused him to go have a bonding moment with his father, that never happened.
If this case was about bad grades of a 16-year-old, if this case was about a 16-year-old lying to his mom about 16-year-old stuff, if this case was about spending an extra $200 to take your pretty girlfriend out to dinner, I'd agree with Mr. Brewer. What is it like to be a 16-year-old? The pressure, the hormones, the ability to try to fit in, all the stuff that happened when we were 16 years old. And we got to remember that. He was 16 years old at that time. Imagine if we had text and cell phones and Facebook when we were 16 years old. What would that be like? All the stuff that they constantly, mind-numbingly kept going over and over again is the banter of a 16-year-old. He's not a perfect kid. Never said he was an angel. But they're asking you to take that and jump over to killing 2 people. Not just 2 people, his parents. They're asking you to make that leap. Mr. Brewer is asking you to take the 16-year-old banter of a knucklehead and jump over to being a capital murder.
Wednesday, April 24th, 2019 ended without any news from the jury, but the following day, they only deliberated for 90 minutes before asking the judge if she could do anything to help them break a deadlock. They were instructed to keep trying and ended up asking to review a few pieces of evidence, including the text message logs, the alarm system logs, and the note written in the house and left at the scene. The jury then told the judge that they were hopelessly deadlocked and ended their second day after trying to reach a verdict for about 8 hours so far combined. The next day, the jury sent a note about being deadlocked for the second time, at which time the judge read them the Allen charge, letting them know that alternate jurors could be forced to come up and replace them should they fail to reach a decision, and they would have an even harder time. After an additional 11 hours of deliberations on day 3, the judge declared that, quote, "I did receive this last note, and the note states we are unable to arrive at a unanimous verdict without causing some members of the jury to do violence to their conscience. It is improbable the jury can reach a verdict, and accordingly, because of that, the court declares a mistrial." The decision was split 8-4 with 8 jurors voting guilty, and since it was a capital murder charge, the verdict needed to be unanimous. The prosecutor released a statement following the hung jury that read in part, quote, "We appreciate the tremendous effort by the jury. Antonio Armstrong Jr. murdered 2 citizens of our county, and we will continue to fight for justice and bring him to trial again." On Friday, April 26, 2019, a then 19-year-old Armstrong Jr. left the courthouse, not heading for jail or prison, but not exonerated either, as he was still out on bond and on house arrest awaiting trial for capital murder again. His new trial date was originally set for October 4th, 2019. However, it was pushed back to January 6th, 2020. But the defense had filed over 30 motions that had to first be addressed before jury selection could proceed. A main focus was what evidence would be admitted, as it had come to light that a garbage bag holding 22 pieces of evidence from the first trial had been thrown out by mistake. Inside that bag was Armstrong Jr.'s cell phone, leading the defense to file a motion to keep the new jury from seeing any text messages found on it. Another pretrial motion addressed what could be damaging evidence for the state, as the defense requested to include Armstrong Jr.'s brother's medical records as evidence in this trial, something they weren't allowed to do the first time around. Since then, the defense had uncovered at least 6 instances where Armstrong Jr.'s brother told doctors during psychiatric evaluations and voluntary admissions forms that he'd witnessed his parents' murders. When committing himself for paranoia, he told the doctor, quote, that in July 2016, both of his parents were murdered in their home. His brother is in custody as a suspect, although he doesn't believe he is guilty. The murder case has progressed slowly as Hurricane Harvey and the pandemic contributed to a large backlog in Houston's court system. After several more hearings and postponements, Judge Kelly Johnson determined that the brothers' medical records can be admitted into evidence, and that she is allowing an alternative perpetrator theory to be presented by the defense at the retrial. That decision was made just over a year ago, and the now almost 23-year-old Antonio Armstrong Jr., who's now a father himself, was back in court on September 19, 2022, and his retrial was set to start in 2 weeks' time on October 3rd. A.J. Armstrong spoke with Courtney Fisher 2 times, once before his trial began and once prior to when he thought his retrial was about to begin in January 2020. Both links are in the show notes for this episode, as are links to the attorney's full arguments. His retrial will feature the same judge, prosecutors, and defense attorneys who, following the mistrial, wondered, quote, "Is this a win? Is it a loss?" In the meantime, as it has for more than 6 years, the search for justice for Don and Antonio Armstrong continues.